He gets repeatedly photoed. One of 2026. Wrong case record. The case record which has been received is not correct. The case records received refer to some other case and not special narcotics PS case number 33 of 2023 full stop. Registry to inform the concerned court to verify and send the correct send the scan copy of the correct case called for by the correct case records called for by the order dated (37-2026). What is the actual case record in this?
My lord, SR number 334 of 2023. Arising out of special narcotic PS case number N33/23.
The trial court, the learned trial court should send the records, a scan copy of the records of
SR number
SR number
334/2023. Arising out of special narcotic PS case number N33/23.
List again on. When was the last time it was listed? On 7th of August 2026.
My lord, if it can be listed, your lordship will be there next week?
Huh?
Your lordship will be there next week or not?
Why should we be there?
My
The
lord,
court will be there.
actually I have some personal difficulty. I had submitted my leave of absence for tomorrow
Okay.
till 11th. So if it may be
On the
listed
12th
on 13th.
13th of August 2026.
Oblige.
Item number 8.
My lord, before I start this case, my lord, on the last occasion, the case diary was called for, and I'm told that, my lord, the case diary has not been received. However, my lord, since the matter pertains to a point of law, probably subject to what the public prosecutor says, we can finish it off today, madam.
Yes, Your Lordship, the case diary is not received yet.
What is the point of law?
My lord, whether the notice served under section 47 is a confession.
Huh?
Is a confession. A confessionary statement is given the shape of a 47 notice. Kindly come to page number 19, the vernacular. Detailed ground of such arrest. My lord will see it is written in vernacular. It is a confession. উপরত কেস লিখা মতে আমার গাড়ীত
ড্ৰাগছ পোৱাৰ
পোৱাৰ
কাৰণে পুলিচে আমাক ধৰিছে আৰু ধৰাৰ কাৰণটো অসমীয়াত বুজাই দিছে. And what else do you need?
This is a confession. I am made to. This is a case where the accusing informing himself in the nature of a confession.
No.
My lord, this honorable court said this is bizarre. I'll show one judgment. Said this is bizarre. The word bizarre is used.
We'll come back at 2.
Yes,
Or
absolutely.
should we we'll come back at 2? Yes.
Absolutely. Absolutely. I saw the indication behind. So, my lord,
Yes, you were saying
referring to page number
19.
19, which contains the section 47 notice, my submission is nothing has been intimated by the police to him. It is rather he is intimating himself, and it is more in the nature of a confession. If I say that I have done it, my lord, it is a confession to whatever little I understand, and this is barred because section 25 of the Evidence Act, a confession made before a police officer is inadmissible. Now, my lord, a similar type of such 47 notice where the accused were made to inform himself was held to be bizarre by this honorable court in a recent judgment, my lord, which I have kindly give that Sabana. My lord, there are two judgments. My lord will kindly take, I'll say the bail number 59/2026. Kindly come to para 11.
Just a minute.
Internal page number 6. My lord is there? May I just read it, my lord? My lord, may skip the first few lines. Can start with further. On the right hand side. 5th line on the right hand side. And this is 1. My second limb of submission is kindly turn to the 48 notice. I'll refer to the original ones. Page number 22. My lord, my submission for petitioner number 1 will cater petitioner number 2 because the notices are identical. So, for the sake of, my lord, page 22, 48 notice. Here also, it is the accused he was made to write it, and it is signed by the accused himself.
Where is it?
Page 22, section 48 notice. Kalamani thus, the contents is explained to the accused in Assamese language which he knows.
I don't find that sentence here.
My lord will see that. Page 22, arrest intimation under section 48, is it that?
This is to inform that in connection with so and so.
Yes,
You may engage a lawyer to represent him.
yes,
His family members are outside the state.
yes,
This intimation is also provided to so and so.
yes, yes.
Where do we find the sentence you are reading?
You are?
You read a sentence. Which one?
No, I am saying the content is explained. This, my lord, the down below written in Assamese language, it is written by the accused himself, and it is signed by the accused, not by his wife.
What is the name of the accused? Accused is Ganesh Das.
My lord, there are two accused persons. One is Karnomani Das and Ganesh Das. I am reading Karnomani Das one.
I don't find any Karnomani Das signature here. I signed Pinky Das here. Acknowledged by
Pinky Das is the wife of Karnomani Das. So they were supposed to inform it to Pinky Das, because Pinky Das is the wife. Under 48, they will inform it to the relative. So they say they have not informed wife the ground of arrest in writing. What they are saying essentially here is this, that they have informed over telephone. And this is written in SMS countersigned, though it is written Pinky Das, but it is signed by the accused himself. It is not Pinky Das. Because 48 is not to the accused, 48 is to the relative, as your lordship knows. Now, my lord will kindly take up. The same thing goes for the Ganesh Das also. Ganesh Das, your lordship will find at page 25.
We have seen that.
The same thing goes. Now, my lord will take the same judgment which I have just now referred, para 12. Not 12. Is bizarre? No. Para 13. Para 13. Now, your lordship may refer to the other judgment which I have given, my lord. Para 8. The other one, para 8. Identical facts.
Yes, we have seen.
Identical facts.
We've
So, my lord, in my respectful submission, this case is covered by these two, and none of these two orders was challenged in any higher authorities, and these orders are in tandem with the mandate laid down in Rehan Kumar as well as Mihir Rajan. And if required, subject to what the learned PP submits, I'll give a rebuttal subject to what he submits. This is, in my respectful submission, these are covered case. Rehan Kumar, my lord, I need not, but still I have a copy. If required, I'll show that this is in tandem and in consonance with the mandate of Rehan Kumar. Because in Rehan Kumar, if your lordship remembers, Justice N. Kotekar Singh devoted a special para 3, only on this issue, where he has categorically stated, he has written 3 paragraphs, because the other part was written by the other judge, my lord, but Justice Kotekar Singh have written only 3 paragraphs, out of which the 3rd paragraph is only devoted on this, that it has to be in writing to the relative, it is equally important. And based on which all this later coordinate bench and single bench judgment followed. I'll just give a copy of Rehan Kumar as well, just to show that para 3. The last para. The last page, your lordship may turn the last page.
In writing, yes, we know that. We remember it.
The penultimate paragraph, the 3rd para. That 50A, which is in perimeteria with 48. It has to be in writing.
Yes, madam, what do you say?
Yes, Your Lordship. I will try to rebut point by point, Your Lordship. And firstly, with regard to section 47, Your Lordship, that is regard to information of arrest, grounds of arrest. And Your Lordship, in the present case, it can be seen that the information is given to him, to the accused, under section 47. And what I would like to submit here is that there is no particular mode. There is no particular mode or format how it has to be given. So here it is very clear that information is given under section 47, and in order to make him aware, the purpose of this section is to make him aware on what grounds he have been arrested. And at the same time, Your Lordship, in this case, this is an NDPS case, and the seized article were seized from the vehicle where the petitioner was boarding. So he is aware on what grounds he is arrested. And that is written here in the information. So the purpose is confined, Your Lordship. And regarding the reliance which he have kept, that is Rehan Kumar. in Vihan Kumar, it is very clear that the information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted.
Without going into the city and all, without going to the Caesar list and all,
Yes.
tell us from this page 19 or page 17.
Page 19.
Page 17. Huh? Page 17 is the English version. Yes?
Yes.
Now, what is the contraband or the drugs found? What is the quantity found, whether it is intermittent, whether it is small quantity, whether it is
Yes.
commercial quantity,
But however, Your Lordship, as per the,
whether it was confiscated from his person or from the vehicle. Without all these things, is the man able to defend himself in a bail?
here
See,
in,
there are quantities
yes,
which will be medicinal. He might be carrying a strip of something
yes,
which he needs to take daily. Yes, that is also recovered from the vehicle. Now I am here for some time. I am bringing my own medicines with me. Yes, under a prescription. So we do not know what is the drugs found. We are going by a simple thing. You have arrested a man standing somewhere on the road. Now you have to tell the man that this is why I have arrested you. Yes?
yes.
You tell him I have found drugs.
But however, Your Lordship, here,
is it a prohibited drug? Is it a narcotic?
here it is written 21C. So obviously he knows that it is commercial quantity. Because in the details grounds of such arrest,
You are
written,
leveling 21C. Now, whether 21C is attracted in this case or not, how does he understand? 2 kilos, 5 kilos, more than the commercial quantity, more than in the intermediate quantity, more than small quantity. How does a man defend himself? Tomorrow you will add here 302. At least, suppose this is a matter of 302, we'll have to take it as a whole thing. The law, if we write down something, that becomes the law, is it not? That will be
Yes.
followed in other cases. Now in a 302, you say, I have arrested you for 302.
and Your Lordship, in that
Child
regard,
is killed, man is killed, where killed, how killed, he knows nothing. He does not even have the information to say that I was not in Aizawl on that day, sir, I was in Kolasip. I could not have murdered him. He does not know, he simply knows it is 302.
yes.
Does it help him?
In that regard, Your Lordship, I would like to rely on one citation that is Kasiredi, but I did not produce the,
No issues.
here it
What
is,
we are trying to find out, madam, is
yes, Your
whether
Lordship.
the information here in 47, without going, let us for a minute presume that we are not in much, we don't agree much to the contention that his writing on this notice is showing that he was not informed. When he writes down this is the reason I am being arrested, we presume he has been told the reason. Now going one step ahead, is this information enough for him or his family to defend himself or to present a bail application? First ground could be, sir, I was carrying commercial quantity maybe, but I had prescriptions for it. Me, my mother and everybody else of us are prescribed the medicine, therefore I have a commercial quantity but under prescription. Yes? It could be, sir, this is not a drug at all. It looks like it, but it is not a drug. He has to say something. He does not know whether it is ganja, he doesn't know it is heroin, he doesn't know it
Your
is
Lordship,
morphine.
if I may be allowed to read out this citation that is Kasiredi, that is paragraph 28. For the purposes of clause 1 of article 22, it is not necessary for the authorities to furnish full details of the offense. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. So, Your Lordship, in the present case, it is written 21C. Subclause B 25/29 NDPS Act.
So
So
21C.
even in the
A commercial
grounds
quantity
for
of
such arrest, it is written that drugs were found in the vehicle in which I was traveling. So he is very much aware.
Every
He himself
drug will have
stated
a
that he
different-
is traveling in the vehicle which he is traveling, the drugs were seized.
What is the
So,
drug? Is it a drug?
Here it is not written
Then
what kind of
how
drugs
would he
is.
defend himself? Tell us.
But,
how would he defend
Your Lordship,
himself?
my submission is that the purpose of Section 47 is complied with.
Okay, 47 complied.
Yes, and with regard to Section 48,
Ah.
Your Lordship, the intimation was given. It is clearly written that his family member are residing outside the state. And since they cannot come to the Sitewell police station, the information of his arrest has been conveyed to his wife Pinky Das, phone number so and so. So it is mentioning here that the phone number was produced by the accused himself. And in that phone number, they contact the wife. So it is complied with. And in that regard, I would like to submit one citation here, the coordinate bench. Para number 12. This is regarding Section 48.
Both cases, para number 12. Very interesting.
This is decided on 16/7/2026, Your Lordship. And this is pertains to Section 48 and 47. And Your Lordship, I would like to rely on another citation, that is State of Meghalaya versus Sonam Raghuvanshi. That is the newly citation decided by the Honorable Supreme Court. Because kung submit ko to eh.
This is different.
I will distinguish it, my lord. Let her complete, my lord. This is not applicable there. This judgment, I'll refer a judgment. Let her complete, my lord. I'll give rebuttal.
Sonam you have given to us.
Yes,
My another citation is
both are. Let her complete, my lord.
2026 SCC online SC 1392.
Yes, yes, we have that.
Okay. So there, in para number 11. If I may read out. We find that the respondent is not entitled for bail, both on merits and on the grounds discussed by both the courts. There is a fundamental difference between non-service of grounds of arrest and non-furnishing of adequate reason thereunder. While the first category might vitiate the arrest, in the second category, one has to see the prejudice caused to the accused. So it is very clear that, Your Lordship, in the present case, the grounds of arrest is furnished. So it does not vitiate the arrest. And even though it might not help me that much, but I would like to submit another citation, Your Lordship. That is State of Punjab versus Balraj Singh. And in this one, Your Lordship, the Supreme Court has again and again stated that the rigors of Section 67 is strictly attracted while discussing the matters of bail. And this matter is covered by commercial quantity, and I would like to submit that citation as well.
What is the other judgment? Balraj Singh, yes. What does it say?
It's regarding section 37, Your Lordship, that one.
But here, a man who has been given that notice, he does not understand anything from this.
Yes, Your Lordship, in the citation which I have serviced, which I have produced, actually there is the difference between non-service and non-furnishing. So if there is a furnishing, so the purpose is
Where is it?
in state of Meghalaya versus Sonam Raghuvanshi,
Huh.
in para
Where
number
before
11.
the trial court she had stated.
Yes, but
That I
however, in
understand why I'm-
paragraph 11, it clearly mentioned that there is a difference between non-servicing and non-furnishing. So if there is a non-servicing, and that's vitiate the arrest. And where there is a furnishing of grounds of arrest, it does not vitiate the arrest. So if they furnish, it is
Where do
written
we
that
know that they have been furnished?
here,
Where do we know?
here they have furnished in the present case, as
And
can
what do
be
you say
seen.
about this judgment which he has read upon 59 of 236? Have you gone through it?
No, Your Lordship, I have not gone through it.
You have not gone through it. You have not given her a copy.
My lord, copies, because my lord, these are all there in the net because she has appeared in that case. Your lordship may see her name appears. She has appeared on the very day. It is,
Yes, another
she
case.
appeared, my lord, so there is no.
Maybe you'll remember Onkothang Haikop and another.
Actually, Your Lordship, at that time also we have made the argument, but
My lord, let her complete, my lord. I'll just take few minutes, my lord. I'll show that neither Raghuvanshi has any application here, not this case. If he's done, my lord, then only I'll speak.
Yes.
so, Your Lordship, what my submission is that in the present case, it can be seen that there is a compliance under section 47 and 48, and in nowhere in the judgment which the appellant counsel had produced, there is no mandate, there is no prescribed form how the grounds of arrest has to be intimated. So they can produce in any kind of form. The only purpose is to make sure that they are aware on what grounds they have been arrested. And my submission is that they are aware on what grounds they have been arrested. And even now, they engage a lawyer to defend themselves. So they are very much aware on what grounds they have been arrested.
Yes, Court Master.
My lord will kindly take up this Sonam Rajvanshi case.
Give this to the people. Madam, you go through para 11 and 14.
My lord, I'll
11
just,
and 13.
my lord, I'll just deal two of the cases which she has referred. And to start with, these cases has no remote applicability. I'll prima facie demonstrate. My lord, Sonam Raghuvanshi, what had happened, my lord, kindly take up that Sonam, this Meghalaya honeymoon murder case, my lord. Kindly take up. My lord is holding this copy, my lord, because it has been.
Any copy, you just go ahead.
My lord will kindly see what had happened in this case. Para number 5, my lord will kindly come. In the earlier ground of arrest, my lord, I'll just narrate the story and then I'll indicate the para. In the earlier ground of arrest, because this particular bail application was the 4th bail application, this one. In the earlier, in the ground of arrest, there was a typographical error to the effect that instead of section 103 capital 3, it was written 403 capital 3. Now, interestingly, BNS contains only 358 section. Now, at the fourth stage, the lawyer comes and takes a plea. This ground of arrest is not adequate because here I was intimated that I am implicated under 403 within bracket 3. He was trying to take advantage of the typographical error. There is no such section at all in the BNS. Then Supreme Court says that intimating ground of arrest and intimating adequate ground of arrest. Here I will demonstrate that Supreme Court says that ground of arrest is mandatory. Kindly come to para 5. I will show that my submissions are based on records. Para 5. My lord is there at para 5, my lord?
Ready.
Ready. Now, on this context, kindly come to para 6. The fourth bail application, and in earlier bail application, they did not take up this plea. Those were contested on merit. Now, my lord, para 9 starts with the line that law is quite subtle, that serving of grounds of arrest is mandatory. Then Supreme Court says this was introduced as a judge-made law, and this difference which they were trying to, and one more thing, my lord, here the Supreme Court said that intimating grounds of arrest in writing was forcefully, put into force by the Supreme Court after Mihir Raj's case, which was prospective. And this incident was prior to Mihir Raj's case. So that is also one factor which persuaded the Supreme Court. That is in para 9 itself. Will apply prospect. Admittedly, in the case on hand, the respondent was arrested on 9/6/2025, much before the date of pronouncement of Mihir Raj. And in my case, that is not. Now in 11, on this context, is Supreme Court goes to say that supplying of ground of arrest, you supply ground of arrest. Adequateness is something else. Adequate is something else. But basic facts must be supplied. Now, my lord, I put a question to myself. Mihir Raj, Prabir Prukaisto, correct? Prabir Prukaisto, Mihir Raj, Bansal, that Pawan Bansal, everything says that grounds of arrest should contain basic details, to make him understand what offense he has constituted. These all judgments are two judgments. Even this judgment, which she has, the worthy counsel for the state has relied, is a two judgment judgment. Now I put a question to myself. If there is, though in my understanding there is no dichotomy, it is absolutely fine. It says adequateness. If there is little bit of variance, which one will prevail? Now, my lord, I take a pause here. This situation cropped up in the principal bench, my lord. What had happened, my lord? There was a judgment, because here in para 9 it says that adequateness, if there is no adequate grounds of arrest, then it does not say ground of arrest. It says adequate. It is prefixed with adequate.
Where do you find that word?
Para 11. The word adequate is important, my lord. What is adequate? For A, adequateness may be something else. For B, it may be something else. It is not that a non-furnishing of adequate reason.
Then?
Now, my lord, this problem cropped up to the principal bench, where in between all these judgments in favor of Article 22, there was one astray judgment where it says the prejudice test was introduced. I'm just coming to that judgment, my lord. Here also there is a prejudice test for the later one. Adequateness, Supreme Court says, if it falls under the second category, then then you will have to demonstrate prejudice. My lord has seen that. Now, my lord, though in my respectful submission, this judgment is not, because here, my lord, there was a typographical error and therefore said it may not be adequate. That will not go into that. Now, my lord, in between all these judgments, there was one judgment, Darshan. I'll give the citation. There was one judgment, Darshan, which has introduced this prejudice test. That unless and until you show prejudice, the arrest per se will not be illegal. Now, this was in straight conflict with Bihan Kumar. Then this matter was referred to a division bench of our High Court. They do the judgment today. Our law Supreme Court to the. It was referred to a division bench of the judge. Our division bench, considering a 5-judge bench, constitutional bench judgment, that judgment also I have, say that if there is a conflicting views between a bench of equal strength, then the earlier will prevail, not the later. I take your lordship straightway to para number. Number para, division bench, DB para, no. That when there is a directive, para 15.
Now, do you deny the fact that Section 48 the grounds of arrest
Yes,
had been intimated to the wife?
I deny it.
That phone number you deny?
No, my lord, from which phone number it was informed? It might have my phone number, but that it was informed to me. What was informed? We don't have anything on record. Law says the burden is on them.
Do we have an affidavit from the wife saying that I did not have notice of it?
Yes, my lord. The affidavit, here the affidavit. My lord, I'm just coming to the factual part. I'll just get done with the. That I am the wife. Pinky Das, affidavit.
So
And-
how are you
And the denial, your lordship will find.
now?
Yes, para 6.
No, tell us about that phone call, whether you received it or not.
No, I have not received it. My lord, the petitioner's back to stated no notice under 48 of the
It is
PNS was
not a-
served
it is-
upon any.
It is not about a notice. It is about, did you receive the phone call?
My lord, assuming, I'm coming to that, my lord.
Moment you assume it,
No, my lord, I'm coming to that judgment.
you would not be very comfortable.
No, my lord, I'm coming to that judgment, my lord, where a phone call was constituted. I'm just coming, just bear with me for a few minutes, my lord. I'm coming to that judgment. It this one. This one. Justice Nelson. With the arrest plan. Huh? Just this will clarify that point.
2 to 3 things will be necessary. Will need either the CD or the orders passed by the trial court when you appeared, for us to evaluate what the
Now, my lord,
APP has submitted.
my lord will see the ground of arrest, the 48 notice here. My lord, just 48 notice to this. My lord will kindly see. Now, my lord, this is also by the same single judge.
Which one?
BA 20/26. My lord, before that, kindly see the 48 notice of that case, which I have given. Just wait. There, the 48 notice is there. Last page. In the last page, the 48 notice, I have just stapled it. Both the type copy and the 48 notice is there. My lord may see whether there is any difference between this 48 notice and the 48 notice at present, which your lordship, the present case.
Yes.
Identical 48 notice. Yes.
In 48 notice, it is said that you have been intimated and you have agreed.
No. There is a phone number. See, kindly see.
That being otherwise.
Yes, there is a phone number of the wife. See, 811-895-240.
Could be.
Was information you prefer to inform regarding your arrest among your family, your such and such, one phone number? Yes. Manipur number such and such was informed in your presence. And it was also countersigned by the same learned single judge. And because, my lord, that case, who argued what, I cannot, my lord, be penalized, because I think the arguments were not made correctly in that case. Because this is also similar, because they have the same format. And the signature was not of the wife, signature was of the accused himself. Same thing. Now kindly come to para 10 of this. Para 7. Kindly, my lord, for a while, para 7. That will further clarify. The same plea has been taken here. Intimation through phone call, para 7. Then kindly come to the finding of the court, because, my lord, that case was not argued well. Kindly come to para 10, because this one was argued by me, my lord, so I can vouch for it. Para 10. Kindly see the findings.
Para 10.
Para 10. Kindly read para 10 for a while. The finding. Clearly written that it is to be in writing, the finding of the court. And the conclusion drawn by the learned single judge is at para 12. The conclusion drawn. Whether there is even an iota of difference between these two cases. That case is an isolated case, my lord. I have given already 3 judgments. There are another 4, 5 judgments. I don't want to burden the court. In that case, my lord, the case was not argued well, because the relevant laws were not placed before the court. Para 12.
Why have you not produced the case diary, madam?
Yes, Your Lordship, I have intimated them and they did not send me yet.
Is absolutely covered by this judgment and other 2 judgments which I have initially given. Same type of formatting 48 notice they have, my lord, with them, where they take the signature of this. That is why I have even stapled the 48 notice to show that these are identical. There are 5 single judge judgments which has clearly held that telephonic intimation is not in consonance with the mandate of 48. It has to be in writing, which flows from Vihan Kumar. This is one isolated judgment. This judgment today morning I have also seen. This is, my lord, the thing was not argued well. I can only say that much. The relevant laws were not taught, because the same learned single judge, when the relevant laws were shown to that judge, came to a completely different finding. That the mandate is in writing. Para 12 clearly says that this telephonic thing will not work. Because there is no record of this. In a telephone conversation, who said what, we do not know.
Thing is, there is something, the judgment where it was allowed
Yes,
is of 23rd of April 2026.
yes.
And the judgment where it was dismissed is of July 2026.
So the law says,
And Your
the
Lordship,
law says the prior one will be applicable.
No, we are not on that.
in that regard,
When
Your
you say
Lordship,
that it was not originally rightly argued and later when the judge was pointed out, he understood it, that is wrong.
No, that was not, but my lord will see that that is one isolated judgment. My lord will kindly see that judgment. Nothing was referred in that judgment.
Your Lordship,
Nothing, not even a,
Let us not discuss the judgment.
if I may, Your Lordship, only one ground. The appellant counsel himself has stated that in the previous order, which I have placed before this honorable court today, he himself has stated that at that time it is not argued well. So my submission is that in this time, in this present time, we have argued it well. So he himself has mentioned that at that time there was no argument regarding that. But at this present of time, we have argued
my
it.
lord,
So he
even
himself
on
has
sole
admitted
ground of
it is an-
section 47, this case, there is no ground of arrest. Number one, my lord, he himself intimated. Number two, there is nothing to indicate that why he was arrested. Drugs found, as your lordship correctly pointed out. This is no ground of arrest. Least we speak of adequate ground of arrest. Adequate ground of arrest may be, my lord, whether from which cavity, from which part of the car, two persons were there, from whose possession what recovered, those may be adequate. But the basic grounds are not there.
To appreciate your grounds, to appreciate what you have submitted, we would require either the CD or the orders passed by the trial court. If you want us to, but then you were given more than 10 days and you have not been able to produce them, what to do? And it is without reason.
If I may be given another 2 days, Your Lordship, to produce the case diary.
Day after tomorrow.
Yes.
We'll have it day after tomorrow. Let her have the CD and the orders of the court on which she places reliance on this thing. What do you say? The Sonam Raghuvanshi case. And otherwise, your arguments have been heard. Our arguments have been. We'll list it on Thursday. Wednesday we may be a little bit rest.
Today is Monday,
Today is Monday. Wednesday is DB day.
but Wednesday single bench sits now after I.
No, we can see.
Even that one is
Only thing is
listed on
if we are
Thursday.
free by Wednesday, we'll have it on Wednesday.
Okay.
If you're here good enough, you can be also there on VC. We encourage that also. There's no difficulty. The only thing we'll consider on that day is whether the CD is there or not. Let us see if the CD contains anything. Otherwise, another two fellows would be roaming around with Wednesday, allowing the PP to allowing the learned PP to produce the case diary and stuff. Matter has been argued at length.
I'm deeply obliged.
Item number 9.
Yes, may it please your lordship. Yes, on behalf of Miss Lelnun Louis, who is the learned GA in this case, my lord, she was supposed to file her written objection, and she has filed her written objection only today. So if the matter may be listed next week, Tuesday, my lord, since this matter is a part of an analogous case.
Those cases are
Yes,
listed on Tuesday.
yes, my lord. No objection, my lord.
It has been submitted on behalf of the learned counsel appearing for the respondent that the objections have been filed today. Full stop. Accordingly, a prayer is made to list this matter along with the objections filed. Full stop. List this matter again on what is Tuesday?
11th of
11th of August 2026. Since it is stated that other similar matters are listed on the said deed. This is for you to withdraw the deposited amount. You would file an IA.
Pardon, my lord.
What was the IA about?
It's an application for disbursing and compensation amount. Half of the compensation amount which is already deposited by the respondents at the
before
fast
the
track court.
executing court, my lord.
Yes, my lord.
Obligement.
Item number 10.
Yes, sir.
Lordship, this is a matter regarding substitution of the next friend. The legal guardian is filing an application for substitution as the legal representative of the applicants. Lordship, this is a case of MSCT claim.
What has happened?
The
Why
applicant, the instant applicant is the mother and legal guardian of the minor, who is the respondent number 1 in the connected MSC appeal number 10 of 2025. And the applicant was appointed by the Learned Court of Additional District and Session Judge Aizol to be the legal guardian because she is the mother and she is the natural guardian.
Natural guardian,
Yes. And she's been looking after the minor. And being appointed as such, she is now trying to be or to stand in the place of the auntie of the minor.
Huh?
The auntie of the minor, she has been representing the minor during the course of the proceeding of the MSC claim. And the MSC claim is over now, and the MSCT case number 3 of 2023 was finally decided by judgment and order at page 15, Your Lordship.
Page 15,
Page
yes.
15.
Yes.
In that, Gracie Larin Sangi is the minor. She is daughter of Dr. Lalampuya. She was represented by C. Zonun Puyi. Zonun Puyi is the sister of the
Mother.
sister of the father. Yes,
Father, okay.
father of the claimant. And now
They have filed
an appeal has been filed.
Ah.
An appeal has been filed against the award,
Ah.
pleading the claimant as respondent number 1. Now, the respondent number 1 still being a minor, she has to be represented by the next friend. And Srimati C. Zonun Pui was the auntie of the minor. And however, the minor was not living with the mother, living with the auntie. She has been living with the mother.
So mother did not know when the MSc case was going on.
She knew, but when she was trying to file the case, and she was informed that the matter will be taken care of by the auntie. And now, since an appeal is being filed against the award, she wants that the matter should be taken care of by the applicant.
Lordship, I'm for respondent number 1. Although I have filed a written objection, my lord, I'm praying that the application may be allowed. Because I am the auntie and I haven't been living with my niece.
You are not living.
No, no, sir.
Yes. Anybody else appearing?
I'm for respondent number 3, my lord.
Respondent number 3 in the appeal.
Yes, my lord.
He's got a guardianship certificate also from the court of law. She has to act as the guardian, huh? So we'll dispose it of
Yes.
that in the substitution. What happened in the mediation?
Mediation, it was not accepted.
Huh?
There's a
But
proposal
Mr.
for
C-
sending it to mediation, but it has not been accepted.
No, I read the order. But Mr. C. Lalram Jawar, Learned Senior Counsel for the applicant, assisted by Mr. Stephen Watsaiha, Learned Counsel. Good stuff. Also heard your name, madam?
Ruth Lalwat Fili.
Mm-hmm.
Ruth Lalwat Fili.
For the
For respondent number 1.
sole respondent, huh? There's only one respondent. In the IA, there is only one respondent.
There's only one.
Oh,
In the IA,
for the
this is respondent number 1.
Hmm. For the respondent number, for the opposite party number 1 in the IA, full stop. Then who is appearing for 2, 3, and 4?
My lord, I'm appearing for respondent number 3.
3.
My lord, I'm appearing on behalf of respondent number 4 and the petitioner in the main.
And who's paying for 2? None. Miss so-and-so appears for the respondent number 3. Mr. So-and-so appears for the respondent number 4. Stroke insurance company. Stroke appellant in the MSC. In MSC appeal number 10 of 2025. Full stop. The father of the opposite party number 1 was a victim of a road traffic accident in which he lost his life, and in such circumstances the opposite party number 1 had initiated MSCT case number 3 of 2023 in the Motor Accidents Claim Tribunal, Aizawl, Mizoram, which came to be disposed of by the judgment dated 27/9/2024. Full stop. In the aforesaid MSCT case, the opposite party number 1 had been represented by her aunt from her father's side, namely Miss C. Zunanpui. Full stop. The Motor Accidents Claim Tribunal, Aizawl, had awarded a compensation of rupees 42,02,760 in favor of the opposite party number 1 herein oblique claimant in the MSCT case, and the same was required no, we cut out that portion. The aunt, the insurance company, namely New India Assurance Company Limited, had filed an MSC appeal number 10 of 2025, arraigned the opposite party number 1 herein as a respondent in the MSC appeal, showing her to be represented by her aunt, aforesaid. Full stop. That during the pendency of the appeal, where is that certificate? When was this found?
At page 11, Lordship.
During the pendency of the MSC appeal, the mother of the opposite party number 1 in this application and also the MSC appeal had secured a guardianship certificate in guardianship certificate case number 86 of 2025 from the court of the additional district and session judge, Aizawl district, Aizawl. Full stop. The operative part of the order is quoted here in below. Full stop. It is at page 10 of the application. I have given this green flag. I have given the tick mark. Okay. Full stop. The learned senior counsel appearing for the applicant has submitted that in view of the guardianship certificate obtained by the mother of the opposite party number 1, the applicant is now required to represent the minor. Full stop. The learned counsels appearing for although an object you recollect this, an objection has been filed by the aunt of the minor claimant, stating that the claim of the applicant herein is a delayed one, and knowing fully well regarding the pendency of the claim, comma, the mother of the child had refrained from participating in the MSC claim, in the claim made before the MSCT, and therefore at this stage she may not be allowed to represent the minor claimant, full stop. The counsel for the respondent number 3 and 4 have submitted that they have not filed their objections in the matter, and the matter may be taken up on merits, full stop. Since the mother of the minor claimant has been able to obtain a guardianship certificate from the Additional District and Session Judge, Aizawl District, Aizawl, comma, this court is of the opinion that the mother of the minor claimant should represent the minor in the accompanying appeal, full stop. Accordingly, this interlocutory application is allowed. The minor, the applicant shall henceforth represent the minor claimant in the MSC appeal. Then you write in the MSC appeal number 10. Today, by an order passed in IA civil number 26 of 2026, comma, Srimati Lalmunia Kimi has been, comma, who is the natural and legal guardian of the minor claimant, has been directed to represent the minor claimant, full stop. Accordingly, who will file that amended cost title?
The appellants may file.
Accordingly,
We can take steps.
appellants, New India Assurance Company Limited shall file an amended cost title in the MSC appeal, bringing on record the applicant in IN Civil 26 of 2026 as the guardian of the minor claimant who had been arraigned as opposite party number 1 in the MSC appeal, full stop. A copy of the MSC appeal shall be served upon the learned counsel for the claimant. Full stop. List this matter again. When?
After 2 weeks, Your Lordship.
Within a week, Your Lordship. The matter has been long pending. Only for substitution of the legal representative.
No, they'll file a amended cost title and
Yes.
they'll give you a copy also.
Yes.
So that is already we have directed that. 13th of August. 13th of August 2026.
No place.
Part 2 hearing, item number 3.
Yes, sir.
Your Lordship, this is jail appeal,
Hmm.
and the present appellant is one of the convicted persons. He is the father and sons were convicted in the present matter, and he is the son. The present appellant is the son who has filed this jail appeal, my lord. They were convicted.
Yes.
The FIR is at page 1 of the paper book, my lord.
Son is before us, na?
Yes, son is before this honorable court. The grounds which I'm going to raise is only two sets of grounds, so to say. One is that on technical grounds regarding the non-compliance of the standing order, which has been made on the basis of this NDNPS Act, Standing Order 1 of 89. Because it says
Standing
about
order?
Standing Order 1 of 89. It speaks about this is the regulations guidelines made under section 52A of NDNPS Act, saying how to take the sample and how to dispose of the sample drawn and the seized articles as well. Those were not complied with, my lord. And the other grounds will be discrepancies in the prosecution evidences with regard to the seizure of the articles. It has casted doubt regarding the seizure also. My lord, FIR is at page 1. Well, I'll just quickly read this FIR only, and the others I will make a verbal submission without reading line by line. FIR, it says that, my lord, I beg to state that on 13/7/2022, traffic cell mobile duty conducted mobile vehicles checking at around 3 p.m. at Dorkai Kon, Champhai, and stopped one Maruti 800 silver color and recovered 22 soap cases containing brown powder suspected to be heroin, total weighing 271 grams, from the possession of two persons, namely Lal Beiseya, he is the father, my lord, son of so and so, and number 2, Lal Nun Kluanga, he is the present appellant, son of Lal Beiseya, both from Vengsang Champhai, from their own vehicle Maruti 800 silver color bearing registration number so and so, driven by one of the alleged accused, Lal Nun Kluanga, son of so and so, Champhai, which they kept inside the back seat of the car Maruti 800, concealed by one bag, while they are proceeding to their residence Vengsang Champhai from Zote Champhai. The recovered items were seized after preparing grounds of belief and seizure memo in the presence of reliable witnesses. The value of the seized article was estimated at rupees approximately international 13.
You start with 1.
Yes.
1 crore.
1 crore 35 lakh 50,000.
50,000.
Yes, approximately international market.
Such huge figures confuse, huh?
Yes.
Yes.
It's sometimes difficult to say it immediately, my lord.
I had a friend who said, if you give me all this money in 100 rupee notes,
Yes.
it will take me more than 15 days. I said, why? You can sit down and count. It is not much money. He said, no, I'll make a mistake. Every time I breathe or I sneeze, I'll make a mistake. I'll forget what I counted.
It can
Yes.
happen, my lord. Yes. And the alleged two accused persons, so and so, both from Vengsang Champhai district, are apprehended along with the seized articles after observing all necessary formalities at the spot. So and so, my lord. So it was, they were booked under section 21C, 25, 29 and the NPS Act. And thereafter, charge was framed and they pleaded not guilty. And page 4 is the 213 examination, my lord.
Yes.
Page 4, the present appellant did not admit to the accusation made against him. And page 6, it starts with PW number 1 evidence. There, 7 prosecution witnesses were cited in the charge sheet, but only 5 prosecution witnesses were
How
examined.
many were there?
7.
7.
Yes. FSL expert, forensic expert, and the chief judicial magistrate and the judicial magistrate were not examined, before whom judicial statement was recorded. Inventory was done.
Who were not examined?
One is the forensic expert,
Forensic expert, yes.
and another one is
Judicial
judicial
officer.
magistrate,
Ah,
CJM, my lord,
judicial magistrate,
Champhai.
Champhai.
They were not examined.
Okay. Ah. Yes.
And my lord, without reading the whole evidences on record, I'll come to my point directly. And before that, let me show your lordship the inventory. There is, because I'm coming directly to the sample which were drawn insufficiently, 5 grams each from 22 soap cases needs to be mandatorily drawn at the time of the drawing the sample, my lord. Page 75 is the inventory before the magistrate. My lord, here, the table shows that 22 soap cases containing brown powder suspected to be heroin, and quantity is altogether, the whole quantity is given here 2721 grams as a whole. And if we see that column marks and numbers, my lord, it is marked as A1 to A10, exhibit B1 to B10, C1 to C2, and nothing had been mentioned about the quantity of each of the soap cases. And I'll come to the standing order, my lord. I'm showing it to your lordship first. Page 76, the next page, is the list of sample drawn. List of the sample drawn. And it doesn't mention about the quantity also, my lord, of each of the soap cases. And
From each of the soap cases.
yes, and if we see this page 75 and 76, my other point will be it is not serially numbered. Sometimes it is numbered as A1, B1, C1. Anyway, I'll come to that point, the standing order. And your lordship, page 77 is the forensic document. That is the reply giving the report of the seized articles. And if we look at that in the middle of the page, description of the exhibits, my lord, it says that each of the sample drawn, that is A1, A2, A3, so and so, it says that the sample drawn which were packed in the packet containing brown powder, it weighs about only 45 mg, and at least not less than 5 grams should be drawn from each of the soap cases, my lord. Altogether, 271 grams was seized as the seized article, the whole quantity. And this page 77 shows that 45 mg, 74 mg, 82 mg, 67, 42, 79, so and so. All are less than 5 grams. So this is my first point, my lord. And apart from this, your lordship, the case IO evidence, that is at page 15, 15 of the paper book, page 15. 15 of the paper book, my lord. Towards the bottom of the page, cross-examination is there. And the first sentence says that it is a fact that samples less than 5 grams were drawn from each soap cases. Even the case IO also admitted to this, my lord. And this is why I'm saying is that, your lordship, I am coming to this, I have given to the bench assistant, your lordship, this laws and regulations standing order, along with judgments I have given. The first set is, your lordship, this standing order. If we look at the first page, it says that this had been made on the basis of section 52A of the NDNPS Act. And if, my lord, if I may take your lordship to para 2.2, page 3. 2.2, 2.3, 2.4, and 2.9, I'll read, your lordship. It says that 2.2 says all the packages containers shall be serially numbered and kept in lots for sampling. Samples from the narcotic drugs and psychotropic substances seized shall be drawn on the spot of recovery in duplicate in the presence of search witnesses panchas and the person from whose possession the drug is recovered, and a mention to this effect should be invariably be made in the panchnama drawn on the spot. Para
This
2.2.
has not been done.
This is, it says that, your lordship, regarding this serially numbered.
But the other part of it is done.
It is done, admittedly. But 2.3, your lordship. The quantity to be drawn in each sample for chemical test shall not be less than 5 grams in respect of all narcotic drugs and psychotropic substances, save in the case of opium, ganja, and charas, hashish, where a quantity of 24 grams in each case is required for chemical test. The same quantities shall be taken for duplicate sample also. This was also not done. The seized drugs in the packages containers shall be well mixed to make it homogeneous and representative both sample in duplicate is drawn. 5 grams, it says that, your lordship, mandatorily, not less than 5 grams. And 2.4, in the case of seizure of a single package container, one sample is duplicate shall be drawn, in duplicate shall be drawn. Normally, it is advisable to draw one sample in duplicate from each package container in case of seizure of more than one package container. And 2.9, your lordship, next page. The sample in duplicate should be kept in heat-sealed plastic bags as it is convenient and safe. The plastic bag containers should be kept in a paper envelope which may be sealed properly. Such sealed envelope may be marked as original and duplicate. This was not complied with. Both the envelopes should also bear the number of the packages or containers from which the sample has been drawn. The duplicate envelope containing the sample will also have a reference of the test memo. This test memo is also not there, my lord. The seals should be legible. This envelope along with test memo should be kept in another envelope which should also be sealed and marked cigarette drug sample test memo to be sent to the chemical laboratory concerned. So I'm concerned with this 5 grams each. At least that was not done. Test memo was not taken and duplicate sample was also not taken. This standing order is mandatory, it has to be followed, my lord. By saying this, I'll rely on 3 judgments, my lord. The first one is I have given the set to your lordship, my lord. This 2008 volume 16 SCC 417. 2008. This is, my lord, para 89 and 91.
Para 8.
89 and 91. Noor Aga versus
91.
State of Punjab. 2008 volume 16 SCC 417. These are short para, my lord. '89, your lordship, may I read? It says that guidelines issued should not only be substantially complied with, but also in a case involving penal proceedings vis-a-vis a departmental proceeding, the rigors of such guidelines may be insisted upon. Another important factor which must be borne in mind is as to whether such directions have been issued in terms of the provisions of the statute or not. When directions are issued by an authority having the legal sanction granted, therefore, it becomes obligatory on the part of the subordinate authorities to comply therewith. Para 91. The logical corollary of these discussions is that the guidelines which are those present in the standing order cannot be blatantly flouted, and substantial compliance therewith must be insisted upon for so that sanctity of the physical evidence in such cases remains intact. Clearly, there has been no substantial compliance with these guidelines by the investigating authority, which leads to drawing of an adverse inference against them, to the effect that had such evidence been produced, the same would have gone against the prosecution. And I'll come directly to just continue this with this para 92, my lord. It says that omission on the part of the prosecution to produce evidence in this behalf must be linked with a second important piece of physical evidence, that the bulk quantity of heroin allegedly recovered indisputably has also not been produced in court. The respondents contended that the same has been destroyed. However, on what authority it was done is not clear. Law requires such an authority must flow from an order passed by the magistrate. And this will be my other points. That is why I'm just continuing to read it, my lord. And another judgment will be 2009 volume 18 SCC 215. Para 36 and 38, my lord. 2009 volume 12 SCC 161.
Huh?
2009 volume 12. Maybe it's yes, my lord. The way I arranged it is,
No, your 2019 is not the one you're referring.
yeah, I will come to that later, my lord. 2009, volume 12.
9, okay.
Yes, 2009, volume 12.
Huh. Paragraph?
Paragraph 36 and 38. Now, 36 says, there is another aspect of the matter which cannot be also be lost sight of. Standing instructions 1 of 88, which had been issued under the Act, lays down the procedure for taking samples. The High Court has noticed that PW7 had taken samples of 25 gram each from all the 5 bags and then mixed them and sent to the laboratory. There is nothing to show that adequate quantity from each bag had been taken. It was a requirement in law. Para 38, my lord. Furthermore, we are dealing with a judgment of acquittal. The High Court, for good and sufficient reasons, had arrived at findings of facts both regard to voluntariness of the purported confessions made by the respondents as also compliance with the mandatory statutory provisions vis-à-vis directions issued by the central government in making search. Seizure as also taking of samples for the purpose of chemical examination having been doubted. We do not see any reason why we should take contrary view, as it is well known that the appellate court would not interfere with the judgment of acquittal because another view is possible. On the other hand, if two views are possibilities strike, the appellate court shall not interfere. Here, this judgment says that your lordship standing order is the requirement in law and it should not be mandatorily, it should be mandatorily complied with. That is why I am citing this. And another one is 2023 SCC online, my lord.
Just a minute.
My lord.
Then, next judgment?
2023 19 SCC 364. Para 7 and 8, my lord. Para 7 says, my lord, in due compliance of section 52A1 of NDNPS Act, the Ministry of Finance, Department of Revenue issued notification so and so, which furnishes an exhaustive manner and mode of disposal of drugs ending with a certificate of destruction, my lord. My lord, I'll skip this part, the quoted lines, and I'll come to para 8. Next page. To be noted, the aforesaid notification which was in existence at the time of the commission of the offence, alleged in the case on hand, stood repealed with effect from so and so, vide notification and so. In any case, a notification issued in derogation of the powers conferred under subsection 1 of section 52A of NDNPS Act can never contradict the main provision, particularly subsection 2. However, any guideline issued by way of a notification in consonance with section 52A of NDNPS Act has to be followed mandatorily.
Now, in our case,
In our case, it has to be followed mandatorily.
why? Because it has already been, it has been repealed. One
Your
of
Lordship,
89
it
once-
is this.
No,
this
no, in 2023 case, answer this question, sir. In 2023 case, this court, the Supreme Court held that at the time of that commission of the offence, one
Yes.
of 89 was in force.
Yes.
When was your person arrested?
He was arrested on 13/7/2022.
13?
13 July 2022.
Oh, it was there.
Yes, so standing order still, it is still valid that time. Now, another instructions had already been issued. I think it is in the year 2023, December, like that. But now, our case is covered by this standing order. So, my lord.
But you did not notice it when I asked you. Huh?
Yes, I have. When it comes there, I was almost confused, your lordship. But anyway, this still
Yes,
covers
so
my
this
case.
also says that it is mandatory.
Yes.
Okay.
And these are my first point. My first ground. And the second ground is these articles were not produced before the trial court during the trial, my lord. And nothing had been mentioned about the order of the magistrate or the trial court for destroying the cease article. Yes, admittedly, it could be destroyed as per the order of the magistrate.
You gave us one judgment, it said so, na?
Yes, yes.
That it had to be produced
And
and the mode and
this is-
manner of destruction has not been proved.
Yes, and Malkhana register was also not produced and it nor exhibited by the case IO, my lord. 2019 volume 18 SCC. 2019 volume 18 SCC. 215. Para 8. Para 8 says, the failure of the prosecution in the present case to relate the seized sample with that seized from the appellant makes the case no different from failure to produce the seized sample itself. In the circumstances, the mere production of laboratory report that the sample tested was narcotics cannot conclusive proof by itself. The sample seized and the tested have to be correlated.
And they have not even examined the forensic
No.
expert and the judicial magistrate.
Yes. They were not examined. And another judgment is, my lord, there is no, while saying this, 2005 volume 3 SCC.
I don't have that.
Yes, para 3.
Yes.
It says, your lordship,
2005 3 SCC.
yes, 2005 volume 3 SCC,
Para?
59, para 3. It says that Malkhana register was not produced. And this loophole vitiates the prosecution case. Here also, nothing was produced, Malkhana register, and even the seized articles also not produced. And the destruction order allegedly passed by the, even if there is any, my lord, it was not exhibited. And nothing was mentioned about by the case IO, about the order for destroying the essay, seized article. And the third point is, your lordship, no acknowledgement receipt from the forensic laboratory to show that the FSL, forensic laboratory, received the sample from the police. There is no such receipt, my lord. That means there is no connection of the evidence from sending the sample to be tested in the forensic laboratory, and there is no receipt saying that it is marked and so, those were received by the forensic. If we look at this from the inventory, my lord, it is at page 75 of the paper book. And sample were drawn, page 76.
75, 76.
And only 77. This is the letter by which the result of the test, forensic test,
Nothing in between.
nothing in between. So it is quite important, your lordship, because I'll rely my submission on this.
In the absence of the Malkhana register, in the absence of the transit document, in the
Yes.
absence of the receipt,
Yes.
what was tested is never known.
Yes, never known. I will be relying upon this Kerala High Court, my lord, 2020 SCC online. Kerala 3139.
Page?
Para 19, my lord.
Para 19.
Yes. It says, my lord, in the absence of the forwarding note marked in evidence, it cannot be found that the prosecution has proved beyond reasonable doubt. So this is what it briefly says. There has to be link evidence. And your lordship, my last point. There are discrepancies in the prosecution evidences regarding the seizure of the articles, which should have amounted to acquittal of the present appellant, my lord. While saying this, I may take your lordship to page 10 of the paper book. Page 10. This is the PW, prosecution witness number 3, my lord. In his cross-examination, it says that cross-examination towards the bottom of the page, my lord. Third para. he said that it is a fact that the seized articles were kept at one shop when I reached the place of occurrence. He is the seizure witness, my lord.
But it was seized from the vehicle.
Yes, that is what I'm trying to say, my lord. This is the one of the independent witnesses. He's from the one NGO. He was called. And however, PW number 4, page 12, your lordship. Page 12. The last line, page 12. This is the PW number 4. He is also one of the independent seizure witnesses. He says that when I reached the place of occurrence, all the seized articles were kept on the rear seat of the vehicle, which was parked near the Dorkaikon Authoric stand. There are contradictions, my lord. And page 13, your lordship, this is again this PW number 4, seizure witness. In the middle of that,
Taken inside.
it is a fact that the seized articles were taken out from the said vehicle by some other police personnel, not the seizing officer himself. He said like that. But the seizing officer, he said that he was the one who zipped open the bag. There is at page 6, my lord.
Taking it out from the vehicle and taking it out from the bag are two different things. The bag may not have been taken out of the vehicle. He
maybe.
might have opened the zip inside the vehicle itself.
Okay, maybe still.
And then after seeing everything, some other person may have carried it. We will not rely much on that, sir.
Yes, but still, your lordship, the other seizure witness saw that bag when he reached the spot. It was kept in one shop. And another witness said that it was kept in the vehicle. So there are some...
This coupled with first line of 13, it is a fact that me and my co-witness arrived at the place of occurrence at the same time.
Yes,
One says it is in the shop, one says it is in the car.
yes, there is. I'll be relying upon that, my lord.
Huh?
There is my...
You are relying because I am pointing it out.
That is another good ground. And yes, okay, I think I will not be able to convince your lordship saying that although the case I said that he himself zipped open that bag, but the other witnesses say that he is not the one who took out. So I'll not press on that point, my lord.
That
Yes.
point we will not take into account.
Yes, and your lordship, PW number 3, that is at page 10. I almost complete my submission, my lord. Page 10, PW 3, he said that in his examination in chief, in the middle of that examination in chief, he says that the seized articles were kept concealed in one bag, dark blue color, within bracket, dark blue color. But if we look at the cross-examination, the third last paragraph, my lord, counting from the bottom of the page, he said that he did not remember the color of the bag. This is also one of the discrepancies. And my lord, page 11, he again said that the second last paragraph of cross-examination, he says that the accused persons never claim ownership of the seized article. And the last point, your lordship, if we look at page 63 of the paper book, page 63, there are two tables, my lord. The second, the below one, if we look at the table at the column, towards the end of the column, counting from the right side, my lord, the second one, method of concealment. I think your lordship got this.
Thorough?
Method of concealment. It says that packed inside transparent polythene inside 22 soap cases. But nowhere in the evidences this transparent polythene was mentioned, my lord. No one, prosecution witnesses. So to sum up my submission, my lord, I'll be relying upon this 2018 volume 1 SCC 222
Para
para 22, 25, 26 and 27.
25.
26 and 27. It says about the contradictions in the evidences of the Caesar witnesses.
Okay.
It creates doubt which could result to acquittal, my lord. I'll not read the whole para, my lord. These are my submissions, and my humble submission is that he may this judgment, impugned judgment, may kindly be set aside and he may
What
be
about,
acquitted.
there were 2 convicts, why only one?
Oh, the father had unfortunately died, my lord.
Acha.
Yes.
While carrying out the sentence.
Yes, your lordship.
Okay. Yes.
Yes, Your Lordship. First, let me rebut the grounds, the first ground which the appellant has, the council has mentioned regarding section 52A and notification, government notification. Your Lordship, what I would like to submit in that regard is that mere incompliance, mere non-compliance of that notification does not vitiate the whole trial. If the foundational fact is proved and the integrity of the contraband articles is not affected with the discrepancies which you have mentioned. And firstly, in that regard, Your Lordship, I would like to relate to one citation that is 2025 8 SCC 452. So without making a long argument, I will just read out this citation. Para number 56.
Bharatambale, huh?
Para 56. Point 56.4. If I may read out. The procedure prescribed by the standing orders, rules in terms of.
Now,
section
madam,
50.
instead of reading the whole thing, let us see it like this. Let us look at the cumulative effect.
Okay.
The sample of 5 gram is not taken. Now, the forensic laboratory expert is not called in.
Yes. Your Lordship, for the forensic expert.
So now how do we know whether less than 5 grams could have undergone a proper test? Whether it was that amount which had reached them, all this will come into play.
Yes, Your Lordship, in that regard, during trial, the integrity is not questioned.
It
and,
is.
It was not questioned at all. So,
No, when you don't bring in the forensic laboratory
yes,
expert,
the
how
forensic
do they
expert,
question
Your
it?
Lordship, as per section 293 CRPC, the report is admissible in evidence. It is admissible.
Oh, we understand that.
Yes.
Thing is that when the procedural lapse is there and the man is not there to prove it, then what happens? When there is a coupling, there is an accident and it is without a helmet. Death.
And Your Lordship, in my humble opinion, in that regard, the defense counsel has to ask to call for the forensic expert. That was not done. The report is exhibited, admitted by him during trial.
Who? Exhibited by whom?
The case IO.
How can he?
And it-
How can he?
and
How,
it was not
how can he?
questioned.
How can he exhibit the report of someone else? He can exhibit the document,
Yes.
but he
exhibit the
cannot
document.
exhibit the contents thereof. He cannot prove the contents thereof.
So in that regard, Your Lordship, in my humble
When
opinion.
when the allegation is that that you have not given the receipt, so what was tested is not there. So that it is the only material which was tested. We'll have to check the chain, madam. If you take up incident wise,
I understand.
then you have got a very good point. But the chain has to be complete somewhere.
Yes.
Now, the forensic expert is not there, the receipt is not there, the sampling is not proper. Then what happens? You are reading 56.4.
And in that regard, Your Lordship, my submission will be that the defense did not question the integrity of the contraband as well as the sample. It was admitted during trial and no dispute arose.
Defense did not
Rebutted.
question the integrity. So it bars him from questioning it now.
And my submission will be minor discrepancies. Does not reshape the whole trial. Once the foundational facts is proved.
What
And
is the
in present,
foundational?
The foundational fact regarding that the accused is in conscious possession
No, that it was recovered from the
from the car,
accused,
driven
from
by
the
him.
car. Now that it is the very sample which was heroin.
Yes.
It could have been 20 grams, it could have been 3 grams. But that sample was sent and that sample was received and that is the sample tested. Once you prove that, only then the foundational fact is proved.
Yes. And
So
during
there is
trial-
no proof to show that the that particular sample was sent because there is no receipt. And the FSL laboratory person is not saying that, yes, this is the only one I had received. So what, that brick is there somewhere.
And my another grounds will be, Your Lordship, since the recovery was done from the vehicle driven by him, in which the appellant has dominion and control over. So the ingredients of conscious possession is proved. And that was not rebutted. And the presumption under section 35 and 54 is not rebutted during trial by the appellant.
Now show us what are the foundational facts which are required to be proved
That
in a
the
narcotics
heroin,
case.
that the sample.
Yes, sir. Madam is saying foundational facts proved.
No, my lord, in the cross-examination of the case IO, page 15, these questions were asked, my lord.
Page 15.
Page 15. Cross-examination, the first line also, it says, Your Lordship, it is a fact that samples less than 5 grams were drawn. And the last sentence of this page, questions were asked. And the answer is, I do not know whether the seized articles were weighed at the place of occurrence or not. But I know for a fact that it has total
This is
weight.
who?
This is the case IO, my lord. And the case IO had only exhibited these documents like inventory and list of samples drawn, but no seized articles was produced before the trial court, my lord. And it was not identified by the other seizure witnesses also. Because there is no destruction order. No, the case IO should have exhibited the order of the magistrate to destroy the seized article if there was any. But nothing was mentioned, and even if it is there, it should have been exhibited by the case IO, my lord. That at least that order. And he did not exhibit the receipt also, my lord, taken from the forensic science laboratory to make the link evidence. In order to
Now
make
at page 11, page 15, this is the IO story, is it?
yes,
He says that the father carried the bag, the son was so drunk he was not being able to drive. So his other son drove the drive, but he arrests only two persons, not the driver. Any way to see that one of them fled?
The other son is cited as PW number 2, Your Lordship.
Huh?
The other son is cited as
He is cited as whom?
prosecution witness. That is PW number 2.
Number 2.
Yes.
Page 8. He was declared as a hostile witness, my lord.
Now look at the FIR. In the FIR, he says that Lalun Luaga,
Luanga.
huh? He was driving the vehicle. PW2 says, no, I was driving the vehicle. He was too drunk to even stand up. There is no history of, there is no mention of any drinking here. Then IO says that yes, he was too drunk. Another was driving. The story is not adding up, madam.
My lord, page 9, PW2 also says that there was no
Did you
civilian witness.
confront him with the FIR? No. His FIR story. It is a fact that on 13/7, one of my so-and-so informed me that they had detained the seized vehicle for violation of mandatory documents under MV Act. Huh? I don't know, things are not adding up. Yes, anything else? Only one judgment.
Yes.
Huh?
Another one is conscious possession, Your Lordship.
You,
that is
you don't want to
2025
give us anything on foundational facts required to be proved. Which is the foundational fact required to be proved? What is the other judgment you are saying, madam?
2025 SCC online SC 122. It is regarding conscious possession.
2025?
SCC online SC 122. That is regarding conscious possession.
Hmm. In your 313 statement, you said that yes.
But depending upon 313, my lord, there is no corroboration from the evidence. He says that it was sent when Burmese nationally has sent us goods, and we did not know what it was.
It was recovered by police personnel.
Yes, they checked the document.
So your explanation is that they have recovered.
The answer is they check the document only, my lord.
Okay, we'll pass orders. Too late now. Heard Mr. Swenson and the counsel appearing for the petitioner, or for the appellant. Also heard the learned APP, Ms. Swenson. Full stop. Arguments concluded, judgment reserved.
Much obliged, my lord.
Thank you.